Judiciary Committee this Friday morning, February 6th, and we're taking up Bill H628. We do have on the agenda to vote on H566, but I know there's at least one member who's testifying in another committee right now, and so we'll do H628 first, which we have a couple witnesses in the walkthrough. Hopefully a fairly straightforward bill. It seems that way, but I will turn it over to Michelle. Thank you for being here, Michelle.
Sure, thank you. So good morning, for the record, Michelle Childs, Office of Legislative Counsel, and we're taking up H628 as introduced. So we're working in Title 15 under the abuse prevention chapter and the civil protection orders. And what this bill does is makes a couple amendments to the final relief from abuse orders. So it's not affecting the temporary emergency orders. So we're just working in section 1103. So first change is on page 2, subsection C, which starts with the intro language on line 6, is that the court is to make such orders as deems necessary to protect the plaintiff, children, or both, if the court finds the defendant has abused the plaintiff, and then subdivision B, you'll see there on line 10, is that it's the defendant is currently incarcerated and been convicted of one of the following certain types of offenses. And this is changing incarcerated to under the supervision of the Department of Corrections. So you still have to have that conviction. We still have to have the C1. So it's just changing it from the person is incarcerated for those offenses, or if it's more broadly that they're under the supervision for those. The next change, the language, kind of the intro language starts on page 2. So looking at subdivision C2, and this is the list of things that the courts can include in the order, right? So things like, that the defendants to refrain from maybe coming within a fixed distance of the plaintiff, maybe that they vacate the family home, things like that. You'll see on page 3, there's a new subdivision F. And again, these are all discretionary for the court. So it's just things tools that are available that can be a condition of the relief from abuse order. And this is adding new language that it would be an order that the defendant continue to pay household bills for which the defendant was responsible at the time the plaintiff requested the order for a fixed period of time. I want to draw your attention to subdivision E, which is current law. Right now, E provides that if the court finds the defendant has a duty to support the plaintiff, they can include in the order that the defendant pay the plaintiff's living expenses for a fixed period of time, not to exceed 3 months. So I think what you'll hear from probably some of the witnesses who had requested this change is the differences between these two. So the new subdivision F is like, so if my partner was responsible for paying the mortgage on our home and I paid for the utilities, that F is specifically directed at that included in the order could be that they continue to pay that mortgage for a fixed period of time. But I just wanted to kind of note the little small differences between E and F. Witnesses can talk to you about why they feel is that change is the additional authority there is needed. But I'll notice that in subdivision E, there is the requirement that the court find that the defendant has a duty to support the plaintiff. And also the fixed period of time is limited to 3 months, and those elements are not in F. And that's it.
Hey, is now the time to talk about the other suggestion as far as codifying the ruling?
Oh, the thing I sent you this morning?
Yeah.
I just sprung that on you because I was just going. It was just something I put out there because I was reviewing some of the case law to see whether or not there was anything helpful around the current interpretation of 2E, and why that might differ from what you have in the new language on 2F. And so there was a case where there was a discussion around when someone requests an extension of an order. So let's say if the initial order is for a year, and you can go in and there is language currently in law that you can ask for the order to be extended. And there was discussion about, well, when do you have to ask for that order to be extended? Does it have to be before the order expires? Can it be like is it supposed to be just like right exactly at that day that it's expiring, or could you do it afterwards? So if it expired and then a week later you're asking for the extension of the order, and the court said that it could be before, at, or after. I don't think it would change anything substantively by putting in that. I just kind of thought to myself, well, it would be better to just clarify that in statute so someone doesn't have to rely necessarily on the court's ruling.
I know what that court ruling was. Yeah.
I defer to the vice chair.
Hypothetical situation. Stay-at-home parent. The other parent is the breadwinner. The stay-at-home parent is the one doing the abusing. And they have to leave the house. Does the person making that has the income have to pay for that person? Even though they're the ones that are abused?
Wait, let me go to your scenario. So stay-at-home person
Is the abuse,
is the defendant. They don't have any income.
right?
Plaintiff is the income, the breadwinner, then they file. I don't think that there's anything in here about that. I can think of, but I'd have to think about it. I never really thought about it because this is about what the plaintiff can get in their relief from abuse order. It's not about the opposite. So does that make sense? So this is like it would be the person who is bringing in the income is the plaintiff in this case. The defendant, who is the stay-at-home person, could be ordered to vacate the family household. There's nothing in the language around the protection order that says you have to.
Right. I didn't know if something in here alluded to it or something we already had. I'm not looking to change it. I'm more curious than anything.
I mean, I think those would be the good questions for the practitioners, for the court to kind of say, these are the kind of scenarios that we see and what might happen there. It could be, a separate family, family court action in terms of support if they're married or been living together for a long time, but not necessarily, I think, part of this order.
Okay, good. Thank you.
That's my guess.
So subsection F makes a lot of sense, looking more at the changes to 1103 on page 2.
Mhm.
So, okay, defendant is currently new language under the supervision of the Department of Corrections. So I would sort of interpret that could be furlough, it could be probation, a number of different things probably, and has been convicted of one of the following. So I think the way I would read that currently, that conviction could be anytime. So I could have been convicted of a domestic assault from 30 years ago and currently be on supervision under DOC for a DUI. Am I reading that right?
I understand what you're saying around, I mean, I think the plain language indicates that. I'd want to look to see whether or not there's been an interpretation, anything different by the court by somehow tying the incarceration to the particular crime there. But in plain reading, it doesn't read that way to me.
So I wonder if we want to clarify or not, but
This is waiting on that as well.
Phrase it, not that familiar with it, I guess. Could there be some sort of family court or preliminary divorce order or anything that could conflict with this that might muddy it?
You can, are you
Who's
thinking,
paying financially, who's responsible for the bills or.
right,
Because you're looking at setting separation and now you have.
right. So if there is, and again, this would be for Judge Zone or, the judges or some of the practitioners who are working with this to talk about what they see in practice. But if there is an existing parental rights and responsibilities order, parent-child contact, there's things around who pays what bills, things like that. The court's going to be able to look to that around.
If it's in the same court, that's right.
You mean like if the divorce order was issued in Washington County and then the APO
I'm
is
just
filed
wondering
in
which one would
Franklin?
take, I would assume the GP's order would.
Well, this is not the emergency.
not
This is, no, this is the one where
Oh.
the defendant, is present and able to respond. So this is for the final. But I think those kinds of things
Yeah.
about how they true that up, what they look to, the information that they have. But this is not related to the emergency where they don't have all the information at their disposal to take a look at.
I was gonna ask a question I think it's around the same thing Tom was saying, that in divorce proceedings, we already have a system in place as far as who pays what. I mean, and I think in a nutshell, it goes, you make this, you make this, you make more, you pay. I mean, and are we reinventing the wheel? But not that this is a bad idea, but are we reinventing the wheel when we could possibly lean on that language that's already being implemented?
Well, if there is an order already, right, it's mostly going to be that you continue to comply with the family division's order around payment and, what you're doing, right? And so it's just going to be, that's going to continue in force. I think what you're talking about is maybe flipping the script, kind of going back to your earlier question.
No, I'm just thinking, I mean, I'm divorced, I've, had child support payments and whatever, and I'm just thinking that, and my ex didn't have any income at the time. I'm just thinking that, real basic, it came down to what I made, what she made, and there's state calculations that figure it out.
Mm-hmm.
And I didn't know if this is reinventing the wheel when we could just use that system.
I have to think about that. And I'm sure probably the witnesses and the folks who are working with this can talk to you about the scenarios and what they're seeing. But essentially this new language is saying that, like let's say I file for an emergency, then a couple weeks later, it's the time for the hearing on the final, right? And if my thing is that, okay, I have been splitting with my partner the household bills, right? And we have figured it out that, he pays this percentage of them and I paid this percentage, right? Is that this is simply saying that, again, the court has discretion here. The court's going to be looking at all of the evidence that's presented. This is, not just the plaintiff at the emergency hearing or when the emergency order is issued, but this is when both parties can be there and have an opportunity to be heard by the court, is that it would allow the judge to issue as for a fixed period of time to say, all right, so defendant has been paying the mortgage for 3 years on this while the plaintiff just pays the utilities. And if you didn't do something like that, it could be that maybe I can't, I'm the plaintiff, I can't afford the mortgage. That's why I have that arrangement with my partner is I pay the utilities and he pays the mortgage.
Right, I just,
So,
I didn't pick up on it earlier, so it sounds like the court still has a lot of discretion.
oh, definitely. Yeah. There's nothing mandated in here. It's that they're because, these cases are so complicated.
Right.
And so it's really about the authorization for the court to look at that. And I think, again, I think when the network had requested this information from the sponsors, this bill from the sponsors, they had practitioners who were saying, the language that's currently in around paying living expenses is not quite addressing all the different scenarios that they see in the practice.
That was gonna be my next question, but I know that's for you,
Okay.
what's happening now.
Did you have a question?
Oh, yeah, I'm just, is there anything in here about the ability of the defendant? Because clearly that could be affected
Right.
and then the whole thing is,
Without knowing for sure, my assumption is that the court is looking at
Right.
those kinds of things. I mean, when you're talking about adding the new F, these were things that the defendant was already paying at the time that the person filed for the order. So they have been paying this. You know, maybe they could say, okay, I've been paying this, but now I literally just lost my job last week so my financial circumstances are different. And that is something that the defendant could, present evidence to the court and say, yes, I was paying the mortgage. I just lost my job last week. And so then the court, again, is not required to be ordering that. They may say, okay, well, in light of that, let's look at what would be fair in this particular situation.
well, if they're under supervision of the department, correct? I think that they're probably not working.
Well, that's not the only
Not
scenario.
entirely,
Yeah, it
but
could be that
they could be on
be
parole.
under, but also under C1A, it's an or. So under C subdivision 1, it's an A or B.
Oh,
So it's that there's a danger for future abuse, or the person is under supervision by corrections for one of those violent offenses.
Any other questions? Okay, thank you very much, and we'll go to Charlie Parker Brooklyn, and thank you for being here, Charlie.
Good morning.
Good morning.
Thank you so much for the opportunity to testify in support of H628. I'm Charlie Lisserman. I'm the policy director at the Vermont Network Against Domestic and Sexual Violence. I'm also joined on the side here by Eddie Poff, who's the director of the Vermont Network's Legal Clinic. This bill includes 2 updates to Vermont's civil RFA statute. And these were issues that were identified by attorneys working with survivors through the Vermont Network's Pro Bono Legal Clinic. I'm going to zoom out a little bit. I'm going to talk about the reason why we're requesting these changes. And as always, you all have fantastic questions that I'm happy to answer, and Eddie can as well as share his perspective as a practitioner. So as you all know, RFAs are a critical legal tool for survivors. They are civil court orders requested by a plaintiff to protect their safety. So to obtain an RFA, the court must find that the defendant has abused the plaintiff, and either there's danger of future abuse, or the defendant has been convicted of one of the serious offenses listed in the statute and is currently incarcerated. So the examples of those offenses include domestic assault, L&L with a child, murder. And what this language proposes to do is replace currently incarcerated with currently under the supervision of DOC. So this proposed amendment would capture those who committed those serious offenses and are incarcerated, as well as those who serve shorter periods of incarceration or subsequently live in the community on probation or parole. As a result of plea agreements, it's common for individuals to serve relatively short sentences or even no time incarcerated for domestic assault. And so this revision would ensure that victims can also avail themselves of the civil protections in these cases. Even if a defendant is under a DOC supervision, the risk of harm and the survivor's fear can remain very real. And in these situations, it may be more difficult for a survivor to meet that threshold of proving danger of future abuse, even though the underlying conduct was severe and could be recent. It's important to update the statute to close that gap and ensure that RFAs are accessible to survivors who need them. The second change that we're looking at, so through an RFA, survivors can seek a range of conditions of relief. They are all optional at the discretion of the judge. Some, not all, can be requested by the plaintiff. And it's really a menu that can address these very individual situations that come up when someone requests an RFA. So these includes protective measures like requiring a defendant to stay a certain distance away from the plaintiff or to not contact the plaintiff. And when appropriate, RFAs can also include time-limited conditions related to shared property, finances, and dependents. And so these conditions can address issues that come up, such as parent-child contact or child support, or determine who may remain in a formerly shared residence. And these conditions are very important in a variety of reasons. And, like Vice Chair was saying, in cases particularly where the plaintiff and the defendant are not married, they can be especially important for addressing conditions that come up when there is no divorce proceeding. So these provisions are really essential because they provide clarity for both parties during the time of the order, they protect survivors, and they also help ensure that survivors have basic resources they need to live independently from their formerly abusive partner. Vermont network attorneys see gaps in how financial responsibilities are addressed in RFAs, which is what inspired this change here. Many survivors had household bills either paid or shared with their abusive partner prior to seeking an RFA. But when the order is filed, those payments often stop. And that leaves survivors suddenly fully responsible for rent or utilities on their own. For survivors, especially those with low incomes, this very abrupt financial burden can be quite harmful. It can lead to missed payments, damaged credit, or even the loss of basic utilities or access to a home, all at a time when survivors are really trying to regain safety and stability in their lives. So H628 proposes explicitly ordering a defendant to continue paying household bills they were previously responsible for at the time of the filing as an optional form of relief. And so this will permit survivors to request the relief and for judges to grant it at their discretion. Thank you for your time and your consideration, and I would be happy to answer any questions.
Yeah, page 3, E and F. What's the difference between those two? I don't think there's a lot of difference, but there's got to be some small thing that makes them different, because E says that, bills will have to be paid up to 3 months. And F says for a fixed period of time. So I guess what's the difference between E and F?
Yes. So there are a couple of differences. So the first is that E requires a finding of a duty to support the plaintiff. F does not. E can be relevant to expenses that the defendant wasn't paying at the time of the RFA filing. E is about if we're already splitting the mortgage 50-50 and I file for an RFA. Pardon?
F is.
Yes, I'm so sorry. F is if we're splitting the mortgage and I file for an RFA, that one of the conditions of relief in the RFA can be that we continue splitting that mortgage. So you wouldn't need to find a duty to support the plaintiff in that case. And that's why it's only specific to the financial arrangements that were previously made by the people who are subject to the order. And
Yeah, I guess I can see a little difference, but even if we didn't have, if F wasn't in there, the court could still make the decision of F.
so the bar is different because E requires that the defendant has a duty to support the plaintiff.
Yeah.
That is not the case with F. So say,
But if you get an order, isn't that the duty to support?
Eddie, I'm wondering if you can talk a little bit about what that duty to support threshold can look like.
Yeah, can you identify yourself for the record?
Sure. Edward.
Or we can wait. I assume he's going to come there. Anyway.
Yeah, why don't we have you come into the witness chair? just-
Eddie.
Where?
Oh, okay. No, listen.
Sit on this bench right here.
Yeah, there we go. Better. All right. Thank you.
Edward Pop, Director of the Legal Clinic at the Vermont Network.
Thank you for having me. So
So
the
I
question,
guess just the difference between E and F, in lay terms, I'm not a lawyer, but I don't see that much difference between them myself, but doesn't mean that there's not.
well, as Charlie's already said, E does have this duty to support requirement. It also does have the 3-month restriction. In practice, I've seen E used very, very infrequently. I'm also not familiar with any case law or statute that would specify exactly what the duty support means. And F has language which is more akin to the interim domestic order, which courts will typically issue automatically upon the filing of a divorce, but not upon the filing of a parentage, because in a parentage matter, there wouldn't be any division of financial assets like there would be in a divorce. So this would offer that same sort of relief within the context of a relief from abuse order. As to your question previously, any of this type of relief that would be issued in an RFA would then be subject to modification in a related family court action pursuant to Rule 4.
So the bottom line here is that there is a gap right now for plaintiffs who have shared living expenses with the defendant. And this would provide the courts another option in that menu so that when these very individual cases come to them, they can make decisions that support survivor safety and feel appropriate to them.
I'm still confused.
And I'm also more than happy to talk one-on-one about it.
Yeah, I'll try one more time. I'm sure it's me. So in E, if the court finds the defendant has a duty, then they have to pay the plaintiff's living expenses for a fixed period of time not to exceed 3 months. What's the difference between that and an order that the defendant continue to pay the household bills? I don't see any difference myself.
So
Either way, they're being told that you have to pay X.
So one example that I can think of to try and articulate the difference might be that a defendant might have a duty to support the plaintiff if the plaintiff maybe doesn't have an income, maybe they were restricted from working by the defendant, and that might greatly limit their ability to cover their household expenses on their own. Whereas in F, maybe the plaintiff has an income. They may not see a duty to support the plaintiff, but that the defendant and the plaintiff had existing financial arrangements that are just continued as a result of this order. So it just opens up the judge's ability to look at the circumstances, the financial arrangements, the incomes of the parties, and make a decision about, for this fixed period of time, how these bills will be paid. I think it's also important to note that in these cases, the defendant and the plaintiff are often, they're being ordered to not contact each other. And so determining what these financial arrangements look like for the term of the order when they cannot talk to each other and sort it out later is very important for the clarity of the parties.
Sure. So the way the law is now, and we have E, could the court come to the determination of F? The way it is now, in their final ruling, what they determine needs to be done, could it already be F?
I think so. There's that different threshold of the duty to support. But then we've also experienced in our legal clinic is that E is very infrequently used, but situations relevant to F come up a lot. And so that's why that gap exists. And so I think at the very least, this provides some clarity about what that option can look like in a courtroom.
I don't have an issue with it because I think they're the same thing, but.
So isn't it essentially that, all right, if the defendant was paying these bills, you need to keep paying these bills for some period of time?
That's exactly right.
Whereas on the first one, it's not just the defendant, fact that they're paying the bills, it's like in fact, they may not be paying all the bills, but they find that you need to support this person for this 3-month period. I guess you're right. It's pretty similar, but I can see it. Yeah, I buy that there was a gap, if that's what you're seeing in actual practice, and if this closes the gap, where the bottom line is the person is paying those bills, you need to keep paying those bills for some period of time.
Yeah, that's what he says.
Not necessarily.
That's not 3 months.
Well, no,
That's what
but
the court
I
determines.
think, is it, that I think another important distinction in E is that what's happened, in a case that where E is applied, the defendant may not already be paying the living expenses or the household bills.
Yeah.
That was for Tom.
yeah, I
Wasn't really for you.
Let's rewind it. I'm sorry.
Yeah, that was my.
I was saying that in E, if E is applicable, it may be the case that the defendant is not already paying the living expenses or certain household bills, that they haven't been, even though the court then finds that they have a duty to do that, they may not have been.
Which
And
goes
then-
back to my scenario, what if the defendant isn't making the money? Doesn't have a job?
These are all options. None of this is required.
Right,
So then the plaintiff would still have a big problem.
right.
Yeah, I think we'll have Judge Zolay come in. I think that he can also add, since he would be, if he tells us that these are not different, then, obviously.
Oh, I'm
But,
sure
yeah.
there's some difference in there, but I just can't see it.
So, Ian.
Yeah, and also avoid like a retaliatory, I don't know if this came up, I was abstract for a moment, but like a retaliatory thing, like someone files an RFA and then their spouse then, well, I guess I'm not gonna pay that my half of the mortgage now kind of thing, right? Like there's that happening. But my question actually is, I don't know who this is to. So under current practice, when we're looking at B, is the incarceration usually being linked to the conviction? Or is it just if they're currently incarcerated and they have a conviction in their record? Is there case law or what's the?
I will let Eddie kind of add any details, but yes, they are often, if not in all the cases that come through our legal clinic linked.
I've never seen C1B is rarely used in general, but I've never heard of a scenario where the conviction is for something completely unrelated to the current incarceration or as proposed under this conviction. But I've never seen it happen.
How would you, I feel like broadening it to any kind of supervision with DOC, there would probably be more instances than the incarceration, right? Like, just given kind of how often people are incarcerated versus how often they're on probation. How would you feel about like explicitly linking them?
I don't think there's an issue with that. It's logical.
It is logical. I would say that because it is not happening in practice, and also the reason why these particular offenses are listed in the statute is because they are the most relevant to domestic abuse. And so I feel like that is kind of a logical takeaway, which is why it is played out in that way.
Makes a lot of sense. I think that my concern in just trying to understand in practice makes a lot of sense. But just because it's an either or, that basically plaintiff doesn't, if we just sort of check those boxes, then there's no need for finding of danger of further abuse. And broadening it to any kind of supervision, I would feel more comfortable if we did like a explicit link between the two. But that's just kind of where I land.
I don't see an issue with that. If if that would be clarifying.
Okay.
Can I just? So I just want to make sure, so is the suggestion that it would say something like the defendant is currently under the supervision of the Department of Corrections and has been for a conviction or related, for a conviction of one of the following?
So defendant is currently under the supervision of the Department of Corrections and is
Being supervised for a conviction.
as related to a conviction of one of the following or something like that. I don't know exactly what the
Yeah.
wording would be.
I know what you meant. I
yeah.
know what you guys are talking about. So I'll just put it.
And I think the broader language with incarceration kind of makes sense. Like, I think you could make a pretty compelling argument that even if it wasn't related to one of these convictions, the guy is sitting in jail right now for something I feel more comfortable about that being broader. But if we're just going to go supervision in general, then making the connection makes more sense. Yeah.
And you still capture folks who are incarcerated.
Because they are under,
They're under the.
I guess that'd be the one place where if it's not happening in practice, then it doesn't really matter. But you would narrow it in that one sense that the way it reads in current law, they don't need to be connected. The person could be incarcerated for something completely different. So we would be narrowing it a little bit in that sense.
But it sounds like that's not a concern.
I don't believe that would be a concern. I would want to see the
Yeah.
revised language. I'm kind of going through the scenarios in my head right now and thinking about say there is we're looking at like one specific survivor, but the defendant harmed a different former partner. I would just want to make sure that all of those kinds of situations are covered. But I believe they would be.
Yeah.
Any other questions for Charlie? All right. So I'll just, one question is as far as whether, are there other individuals you think that we should hear from on this? I mean, we'll get Judge Zone in, but anybody else from your perspective? And if you could just let me know if you can think of that.
I will think on it, but I think hearing from Judge Sony would be great.
Okay, great. So, all right, so we're going to hear from Kim McManus and I just like a reflex put you on the agenda, Kim, even though it's probably fairly narrow since this is a civil kind of action. And I'm trying to find a hook so I haven't wasted your time. So maybe it's on the enforcement of violations of a protective order, but I'll let you, whatever you want to say on this. But I apologize if I brought you here and it's not within your realm. Over to you. Thank you, Kim. With that introduction.
A wonderful introduction. For the record, Kim McManus, Department of State's Attorneys and Sheriffs. I always appreciate being put on the calendar, so feel free to just throw me on there all the time. So yes, we are to the side of this in the State's Attorney's Office, but we do see obviously considerable overlap, particularly in our domestic violence cases, where our victim survivors are also applying for relief from abuse cases. And so from our department's perspective, we can add that we are very aware that economic manipulation is a massive part of the power and control dynamic in abusive situations. Many times abusers use finances to control the victim, knowing that it's harder for them to leave if they do not have some financial underpinnings that'll keep them safe. And that often victims are put into situations where they either don't file for a relief from abuse order, or if they do file one, they quickly ask for it to be rescinded because they are in dire economic situations. So from that perspective, we do appreciate this addition, which widens what the court can consider as far as ordering for expenses to be paid. I would just like to bring up, and again, you'll have practitioners who will know, maybe be able to give you more detail, but when the discussion was going on about E and F and the duty to support, we have to remember that's a legal duty to support, right? Not a moral duty. And in these situations, sometimes this is a married couple, sometimes this is roommates. So there's a very different standard there. Sometimes this could be a caretaker, someone who has a guardianship and lives in the home. So I think that's where, when you're looking at reaching that duty to support, you have to show a legal duty there, and that is a higher standard than what would be required in F. And again, just to highlight, and you have many experts who can come in on this, we often see defendants control the household bills, will often not have the victim on the billing statements. It's hard for them to even be able to pay the bills, that sort of thing. So F definitely captures those instances far more than E, but as Vice Chair was pointing out, there's definitely overlap. If this was a Venn diagram, there's going to be situations that overlap, but F definitely incorporates more scenarios.
Any questions? Does that help?
Yeah.
Yeah. So, yeah, thank you. So thank you, and thank you for actually being here, and I didn't make a mistake having you come after all. So that was not that it would ever be a mistake having Tim McManus testify here. Let me just make that clear. But no, that's very helpful. No, that is very helpful, and it does bring this into the context that these do overlap often with the criminal charges as well. So
they do, and just to underscore that, when if victims are fearful that the protective order is not going to protect them, that often can influence the outcome in our criminal case. So it definitely impacts our world.
right, appreciate that. All right, excellent. So we will get Judge Zone in, and I don't know. I mean, I can invite the Defender General's office. I don't know if they'd be interested, but they might be. So I'll write that down, and we'll try to get those too. But all right, thank you very much. So we're going to now turn to H566, and if Michelle can join us again on that one, and you all should have draft number 3.1 scheduled for possible vote.
Thank you.
We do have one addition to this, one amendment to this. So
Already made it.
yes, no, I mean just for everybody that we haven't seen, that we talked about yesterday.
Yeah.
And do folks feel that we need to have Michelle actually walk through all of it, or just a new language? I'm not seeing anybody saying, let's look at it yet again. Just a new language. All right, over to you, Michelle.
Good morning. For the record, Michelle Childs, Office of Legislative Counsel, and we're looking at draft 3.2, dated just about an hour ago. The times. So the new language is all the way. And so this relates to, you'll recall that the initial proposal was on adult diversion program, was to add eligibility for criminal municipal ordinance violations. You decided not to go there and broaden it holistically statewide at this point, but you did want to continue to support the AG's work with the Burlington Community Justice Center and sending some of those types of ordinance violations to the Burlington Community Justice Center. And so you'll see on page 8, section 3, I just added some session law because we don't want to go in and amend the statutory language just because of, with this kind of short-term project. But I'm basically retroactively authorizing them to do it. So, so you can see starting on line 16, new session law. So notwithstanding the limitation in 3 VSA 164A2. So that's the provision in current law that says what types of cases can go. And it talks about a violation of criminal statutes. I understand that the Attorney General's office said, no, I think we can do it under that, but I think that's debatable. And so I just wanted to make sure I'm notwithstanding that So it's clear that saying we're making an exception here, that this is okay. And it's just authorizing that program in Burlington. And from January 1st, 2026, right? So it's operating now through July 1st of 2027. Willa had asked for it to be just for a period of a year, which was what their anticipation, but it can, in consultation with a couple of the members there, decided that, well, y'all actually won't be back as of January 1st, 2027. So might as well give yourself a little more time to kind of figure out and consult whether or not you want to extend that project or you want to go towards moving to amend the statute to allow for statewide authorization for those types of programs.
Okay, are there any questions on that or anything else with respect to the debt? All right. Yeah, go ahead, please.
So I'm just wondering about the section right below the effective dates. Because it's session law, it doesn't need to also add. Okay, no, it does. I'm sorry. Never mind. It was one of those. It was excellent.
Okay. All right, so are we ready to move on this?
No.
Yes, right.
That's all. I will, so I'll have two motions. I'll start with a couple, and that is a motion to approve the strike all amendment, draft number 3.1.
3.2.
3.2.
Emotion?
I make a motion to approve strike all amendment draft number 3.2.
Second. All those in favor of the amendment, raise your hands. Any opposed? All right, now I'll take a motion that we report H 566 favorable with the strike all amendment.
We have any discussion?
I'll take the motion, then we can have discussion.
So moved.
In a second?
I'll second.
All right, yeah, let's have some discussion, please.
I think I've really enjoyed, maybe that's not the right word. I found it very helpful hearing the testimony on this bill and sort of the continuation of the discussion between sealing and expungement. I just want to note from my own perspective that we heard the term, it's a legal fiction between the concept of expungement and the concept of sealing. I would just push back that they are not the same. And even though, when we're talking about sealing and we're talking about expungement, there are two realms. One is the public sphere and how your criminal history is sort of reflected in the public. And that I can sort of see the argument around legal fiction. Other half of it is the use of it in law enforcement. That's where it's not a legal fiction. It does make a big difference if it's sealed or expunged. I don't think that in any way impacts my support of the bill, but I just want it to be made really clear that having a sealed record for a diversion could impact someone's opportunity to get a diversion offer in the future, something like that. And that's not a fiction. So given all that and all of what we heard, I think I'm actually moved more in favor of sealing than I was even earlier in the session, as we've discussed more and more the importance of some ways maintaining criminal records in very restricted ways and not destroying public records generally. So I just appreciate the opportunity that we've had to discuss it, and I'm looking forward to voting for it.
No, thank you. No, that's good clarification. Any other discussion? The clerk, go ahead, Barbara.
Ian reminds me that I very much have concerns about the fact that we're sealing juvenile records and the whole concept of the juvenile justice system, which I know is not something we have implemented in this bill, but something that I found hard to support last year. And while that isn't in this bill, Ian reminding me of it definitely brings up my strong feelings of the need to look at going forward if it's hurting kids because we're sealing, expunging, and undoing the whole theoretical concept of our juvenile justice system.
Okay. All right. Tom?
Yeah, I personally think sealing is important. And one of the big reasons is records, recidivism, rates. And, with the records and the information, trends can be seen as far as, what's happening out in the real world. And that way we can react to that in here potentially to, whether it's programs, laws, or whatever to, try to curb things. And I think going forward, it's gonna be a few years, once we compile more information, with the sealing we've already done and with this. I really think it's gonna be helpful in the long run and help people more than there is some people that are gonna be damaged by it, but I can't think of a word that's not quite as strong as that, but I think overall it's gonna be helpful in the juvenile justice world. So,
Well, thanks, Tom. I agree. So, anybody else? So the clerk could call the roll.
Arsenal,
Yes.
Dolan,
Yes.
Goodnow,
Yes.
Osling, yes, Harvey,
Yes.
Malay,
Yes.
Oliver,
Yes.
Rachelson,
Yes.
Christie, Burdick,
Yes.
Lalonde.
Yes. So as far as the reporter, if anybody who hasn't reported a bill yet, I'll give you first dibs. Tom, do you want to report? Zach, you want to report? You game?
Yeah.
Report this? Okay, all right, so Tom.
compile tough questions for all your friends.
Yeah, we'll get some questions out there. We'll get some questions.
Where are the municipal criminals?
We got rid of them.
Why are we not? So, all right, great. Nate will help you make sure that you get the stuff that you need to have there, and I'm sure Michelle will help with whatever the.
I was gonna say something before we voted on.
Well, you did.
Well, no,
Raise your hand.
I don't like this bill. I don't want to report
Are you
it.
doing a post-vote explanation?
You can still
Do you want me to do a post vote after?
do.
Yeah, I will. I'll brief one. I think, we started out with diversion. Diversion was a one-shot deal for a lot of years, and then they opened it up so people could have more than one stab at it. And then they wanted to get rid of it. And it became a problem when you start to expunge the record. And then now we're sealing it, but now you're gonna reveal that somebody maybe been through diversion before. So I think we're slowly kind of coming into a sweet spot, so to speak. I personally have always thought that the one-shot deal at diversion with a complete expungement at that point was good. But I think this is a great problem. And it's very helpful.
All right, so we have Big Hartman coming in at 1 for about a half hour. I've asked her just to keep it short on their budget request for the Human Rights Commission. Because next week we have a busy week with a lot of budget presentations, with the presentation on Monday morning on criminal justice. It's Wednesday morning.
Okay, all right, sorry.
Sorry, boy, I tell you, it's a week. So Wednesday morning, mainly focused on the 3B pilot, or the docket in Chittenden County. And a couple bills we're going to be taking up, the no-show bill of Representative Oliver and me, and the trial supervision bill, I think. So anyway, busy week, but we'll adjourn now until 1 o'clock and go off live.